Okay, reading page 501 of Disability Rights Law by Sam Baganistos. In chapter 5 about private housing and public accommodations, section B, physical accessibility. Case number 51 out of this book is titled Molski versus Foley Estates Vineyard and Winery. And this was heard by the United States Court of Appeals for the Ninth Circuit in 2008. This case involves a paraplegic who encountered discriminatory barriers to access when he visited a winery with his grandmother. Unwilling to remove barriers to the historic wine tasting room, Foley Estates Vineyard and Winery, Foley, nicknamed Foley, began providing services on a gazebo with a big bell where individuals barred from the wine tasting room could ring for service. Jarek Molski and Disability Rights Enforcement Education Services, nicknamed DREES, sued Foley for injunctive relief and damages to redress physical barriers to wheelchair accessibility. The district court ordered barrier removal within the building, but determined that it would not be readily achievable to make an accessible ramp to the entrance. We affirm the injunction requiring barrier removal within the building, and we remand for the district court to apply section Title 28 of the Code of Federal Regulations, Section 36.405, and the Americans with Disabilities Act accessibility guidelines for buildings and facilities when evaluating whether an accessible ramp would be readily achievable. The factual and procedural background is as follows. On January 18th of 2003, Jarek Molski visited the Foley Estates Winery with his grandmother. While attending a wine tasting, Molski encountered multiple physical barriers to entry with his wheelchair. An accessibility expert, Rick Sarenshin, conducted a sub rosa investigation of the property on October 12th of 2003. Sarenshin confirmed the existence of barriers to entry, including a ramp with a slope that varies between 6% and 20%, a raised threshold measuring 4.5 inches, a round doorknob, a rear door width of only 30 inches, another door width of 31.25 inches, and wine tasting counter height of 42 inches. Jarek Molski and DREES filed suit against Foley on December 22nd of 2003. Prior to the commencement of litigation, Foley undertook $23,994 in renovations to provide all services on a wheelchair-accessible gazebo. Renovations included an accessible ramp from the parking lot and a big bell to summon for service. Nearly 2 years into the court proceedings, the Santa Barbara County Historic Landmarks Advisory Commission declared Foley Estates a place of historical merit by way of resolution number 2005-01. At trial, the court heard expert testimony regarding proposed methods of barrier removal and associated costs. The court also heard testimony from Foley's architectural historian, who opined that an access ramp would have severe impact on the historical nature of the cottage. How much did this the gazebo cost? $23,000. Okay, so here's the barriers in great detail and a wheelchair accessible gazebo. Anyway, the architectural historian opined that the access ramp would have a severe impact on the historical nature of the cottage. The judge determined that it would cost $34,074 to construct an access ramp to the rear of the building, and it would cost $5,130 to remove all physical access barriers inside the building. The judge found that removal of internal barriers would be readily achievable, but removal of external barriers would not be readily achievable because it would threaten the architectural significance of the property. In reaching this finding, the judge held that under the section I described earlier and the ADA accessibility guidelines, section 4.1.7, do not apply to barrier removal for existing facilities. Thus, the judge allocated the burden of production to the plaintiff to show that the proposed alteration would not threaten the historic significance of the building. The trial judge assumed a permanent injunction requiring barrier removal inside the cottage. Drees timely appeals the district court's findings regarding the applicability of the Code of Federal Regulations section and the ADA-AG and the ready achievability of constructing an accessible ramp. Foley cross appeals and challenges the permanent injunction requiring removal of interior physical barriers. Sort of silly. Discussion. Part 1. Exterior ramp applicable regulations. On appeal, we are asked to decide whether Section 36405 of Title 28 of the Code of Federal Regulations and 4.1.7 of the ADA-AG apply to barrier removal in existing facilities. By their terms, these regulations apply to alterations. However, the CFR extends their application to readily achievable barrier removal in existing facilities. Despite this regulatory directive, the district court declined to apply 36405 and 4.1.7. We reverse and remand. Our analysis begins with the CFR, which regulates barrier removal in existing facilities of public accommodation. That section requires a public accommodation to remove architectural barriers in existing facilities where such removal is readily achievable. We got it. Regulation goes on to specify that measures taken to comply with the barrier removal requirements of this section shall comply with the applicable requirements for alterations in different sections. If compliance under those additional regulations would not be readily achievable, a public accommodation may take other readily achievable measures to remove the barrier that will not fully comply with the specified requirements. In this case, we look to the regulations governing historical buildings because the Santa Barbara County Historic Landmarks Advisory Commission designed the building as a place of historical merit. Through its plain language, the CFR directs vendors to comply with this section when making readily achievable accommodations. That section requires qualified historical buildings to comply to the maximum extent feasible with 4.1.7 of the ADA-AG and the CFR. That's just the citation. Under 4.1.7, if the entity undertaking the alterations believes that compliance with the requirements would threaten or destroy the historic significance of the building, the entity should consult with the state historic preservation officer. And if he agrees that compliance with the accessibility requirements for accessible routes, exterior and interior ramps, entrances, or toilets would threaten or destroy the historical significance of the building or facility, the alternative requirements of of 4.1.73 may be used. Under our reading of the CFR, that section requires compliance with another section which incorporates 4.1.7 and provides a procedure for businesses to seek alternative requirements for historic properties. Our reading of the CFR preserves the leniency allocated to existing facilities under Title III of the ADA. The ADA only requires barrier removal in existing facilities where such removal is readily achievable. And now we cite the ADA. Section 36.304, which is the Code of Federal Regulation, integrates the readily achievable standard into both 36.304A and 304D2. Section 304A ensures that only readily achievable barrier removal triggers the incorporation of 36.405 and 4.1.7. I didn't earlier didn't distinguish that 405 requires qualified historical buildings to comply to the maximum extent feasible with the accessibility guidelines 4.1.7. So now you know that we're talking about the CFR. We're talking about two different sections of the CFR. CFR 304 is the one discussing existing facilities of public accommodation should remove their barriers when readily achievable. And then, 405 points to the accessibility guidelines. It incorporates the accessibility guidelines into the Code of Federal Regulations. So back to this, 304 allows for partial compliance. If full compliance with those regulations would not be readily achievable. Thus, Section 304 incorporates 405, which incorporates 4.1.7 into the readily achievable framework and retains the flexibility standard reserved for existing facilities. Additionally, 4.1.7 establishes a procedure for determining whether barrier removal in existing facilities will be readily achievable. So we're talking about a flexibility standard, we're talking about a framework. According to the ADA Title III Technical Assistance Manual, barrier removal would not be considered readily achievable if it would threaten or destroy the historic significance of a building or facility that is designated as historic under state or local law. The standard set in 4.1.7 is identical to the standard of readily achievable proffered by the ADA manual. This similarity between the language suggests that application of 4.1.7 is consistent with the standard for existing historical facilities. Therefore, the procedure set forth in 4.1.7 may be used to determine what is readily achievable in existing historic facilities. For the foregoing reasons, we find that this district court erred when it refused to apply Section 36.405 and 4.1.7 to readily achievable barrier removal in existing facilities. We acknowledge that three courts have considered historical significance as a factor for determining ready achievability without invoking the 36.405 or the ADAAG Section 4.1.7. However, we find the explicit regulatory language to be more persuasive than the absence of discussion of these regulations in our sister circuits. Therefore, we remand to the district court to apply those sections when determining whether an exterior ramp would be readily achievable. So this is like their holding and their opinion on the issue of readily achievable framework. And the burden of production is section B of the discussion about the exterior ramp. So the applicable regulations we just read. Now we're going into the burden of production before we talk about internal barriers. So at trial, the judge relied on Colorado Cross Disability Coalition versus the Hermanson Family Ltd. to find that Dries bore and the initial burden of production for the question of ready achievability. As noted above, Colorado Cross failed to address Section 405 and 4.1.7. This omission tainted the inquiry into who bears the burden of production for the ready achievability of barrier removal in historic facilities. We reverse and remand because we find that 4.1.7 counsels in favor of placing the burden of production on the defendant. We begin by looking into 36.405 and 4.1.7 to allocate the burden of production. Under 4.1.7, if the entity undertaking alterations believes that compliance with the requirements would threaten or destroy the historical significance of the building, the entity should consult with the State Historic Preservation Officer. Although this clause uses permissive language, it calls upon the party who believes that compliance would threaten the historical significance of the building to consult the appropriate agency. It does not place that burden on the party advocating for remedial measures. Thus, the language of 4.1.7(2)b counsels in favor of placing the burden of production upon the defendant. Okay, so they're saying in case law, they didn't, case law failed to look at the ADA-AG, which in establishment of burden of proof, which is why they placed it on the plaintiff versus the defendant. That makes sense. By placing the burden of production on the defendant, we place the burden on the party in the best access of information regarding the historical significance of the building. The defendant sought the historical designation in this case. Thus, the defendant possesses the best understanding of the circumstances under which that designation might be threatened. The defendant is also in the best position to discuss the matter with Santa Barbara County Historic Landmarks Advisory Commission and to request an opinion on proposed methods of barrier removal. As a result, the defendant is in a better position to introduce, as part of its affirmative defense, detailed evidence and expert testimony concerning whether the significance of a structure could be threatened or destroyed by a proposed barrier removal plan. As the dissent reasoned in Colorado Cross, if plaintiffs must all but present the court with a pre-approved construction contract for a sum certain, which includes detailed plans, impact statements, engineering studies, and permits to meet their threshold burden, virtually no plaintiff could afford to bring an architectural barrier removal claim under the ADA. And that's the citation. We need not require an ADA plaintiff to undertake such heroic measures. Congress relies on private actors, i.e. disabled individuals, to enforce the ADA by filing lawsuits. Thus, plaintiffs should not be deterred from filing meritorious claims by an inappropriate allocation of the burden of production. We find that the language of 4.1.7 so they just really didn't like the case I just read. They agree with the dissenting opinion and they disagree with the burden of production, which is really the same issue. We find that the language of section 4.1.7, the access to information and the congressional intent behind the ADA, and that's their support, access to information and the congressional intent, those are the pieces for analysis. Behind the ADA support placing the burden of production on the defendant. Thus, we reverse and remand for the district court to assign the burden of production to the defendant on the issue of whether barrier removal would threaten the historical significance of the building. Now, section 2 of the discussion relates to the duty to remove interior barriers. And when the district court ordered removal of interior barriers to the building, the court arguably enhanced the probability that persons with disabilities would attempt to traverse the non-compliant ramp to access the building. Foley argues that we should absolve the winery of its responsibility to remove interior barriers because the only existing ramp is non-compliant. We reject this argument and affirm the district court's injunction requiring barrier removal inside the building. So that's kind of the issue. Both parties find support for their positions in Title 28 of the Code of Federal Regulations, Section 36.304 D2. According to the regulation, If the measures required to remove a barrier would not be readily achievable, a public accommodation may take other readily achievable measures to remove the barrier that do not fully comply with the specified requirements. Such measures include, for example, providing a ramp with a steeper slope. No measure shall be taken, however, that poses a significant risk to the health or safety of individuals with disabilities or others. That same section cited. Dries relies on the provision for partial accommodation wherever complete accommodation is not readily achievable. So Dries relies on the provision for partial. And what provision is that? Foley relies on the caution against partial accommodations where they pose a significant risk to health and safety. We find that partial accommodation was appropriate in this case. They're both in the same section. First, Section 36304 D2 expressly contemplates that a venue may provide a ramp with a steeper slope. The provision of the ramp does not excuse the facility from otherwise making readily achievable accommodations to the maximum extent feasible. Therefore, the fact that there is an existing ramp with a steeper slope also does not excuse the facility from making readily achievable accommodations to the maximum extent feasible. Second, the inaccessibility of entry to one group of individuals does not justify retaining barriers to access inside the building for all others who may safely gain entry. Where readily achievable, the interior of the building must be made accessible for all who may enter. Foley argues that removing barriers to the interior of the building might tempt people with disabilities to traverse a ramp that is nearly 12% steeper at points than ADA guidelines recommend. According to Foley, this temptation implicates the same section because it imposes a significant risk to the health or safety of individuals with disabilities. When weighing this consideration, we recognize the diversity in the population of persons with disabilities who might seek to use this ramp. People using canes, walkers, braces, and powered chairs can often navigate a steeper ramp than people using manual chairs, so safety risks vary with the nature of the disability and adaptive equipment. Notably, the only evidence that Foley cites to support his theory of health and safety risk is the pleading of a manual wheelchair user who complained of trauma to his upper extremities. Although the ramp allegedly caused injury to Jarek Molski, the ramp might not cause injury to people using different adaptive equipment. Because safe access is possible for many persons who might need to use the ramp, the district court did not abuse its discretion by ordering readily achievable accommodations to the interior of the wine tasting room. And Section 3, the alternative gazebo. Foley argues that the provision of all relevant services on the wheelchair accessible gazebo was legally adequate as a means of barrier removal. We reject this argument and affirm the district court's imposition of readily achievable barrier removal inside the building. As a threshold matter, a facility may only substitute alternatives to barrier removal where, as a result of compliance with the alteration requirements specified in paragraph D1 of this section, the measures required to remove a barrier would not be readily achievable. As noted above, the district court did not abuse its discretion in determining that barrier removal inside the building was readily achievable. In light of its holding, no alternative accommodations can supplant the legally required barrier removal. Although we find the gazebo inadequate for those who could otherwise access the wine tasting room, the gazebo provides an important avenue of participation for those who cannot traverse the steps or ramp to the wine tasting room. We acknowledge Foley's efforts to serve his community. However, these efforts do not change Foley's obligation to make readily available changes to enable the maximum participation possible for those who are able to access the interior of the wine tasting room. The gazebo places those who could otherwise access the wine tasting room at a disadvantage, and the ADA seeks to remove. Thus, the gazebo is not appropriate alternative accommodation. So, in conclusion, we reverse and remand for the district court to apply Section 36405 and 4.1.7 and place the burden of production on the defendant. Additionally, we affirm the district court's permanent injunction requiring removal of the interior barriers to wheelchair access. And you have concurring and dissenting opinions that follow.